One of the issues in legal history and cultures of law is whether a judge who has direct knowledge of a thing can rule per that direct knowledge, or is the judge bound by the rules of evidence. So I could be sitting as a judge and I could have direct knowledge. I can take judicial notice of whether you are guilty or not, because let's say I, as a judge, saw you commit the act. But the evidence could be lacking. In what in legal sociology we often in often called folk systems of law, from folklore, is that the rules of evidence are not codified and not set in stone, and therefore negotiable. And it takes legal sociology and legal history quite a while to get to the point where you say you don't have justice unless the rules are the same for everyone. So even if the judge has direct knowledge, a judge may not rely on direct judicial knowledge, but must rely on the rules of the process for adjudication. It is remarkable that you find it in the Qur'an, and because of that, Islamic law, centuries before it became a common feature in legal systems and rule of law systems, in Islamic law, Muslim jurists were, because of the Qur'an, had from the very beginning, early centuries of Islamic law, said that a judge may not rule based on judicial knowledge, that a judge is bound by the rule of evidence. That civilizational leap came from the Quran. And that Allah, if Allah's self, God's self, is saying, I will consider whether you are saying the truth or not, depending on whether you comply with the rules of evidence or not, then a priori, it applies all the much more so to human beings.